It is the voice of Indiana County, WCCS 101.1 FM, AM 1160, WCCSradio.com. Time for another installment of Marshall Law with attorney Marshall Chriswell. And this program intended for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Say a guy like Marshall Chriswell, who joins us on this cold January morning. Good morning.
Good morning.
Hey, it's good to have you. This is a topic to warm up with. Okay, well, maybe not. But it is an interesting one. I've just heard this this phraseology for the first time ever, so you'll have to inform me on this one. What is a quiet title action?
A quiet title action, Todd, is a funny name for a special kind of lawsuit, special kind of suit that you file with the court to determine the ownership of real estate. So to determine who owns a particular tract of real estate, or who owns a part of a tract, to settle a boundary dispute, to determine rights in an easement or right-of-way, to determine who owns oil and gas or what percentage of oil and gas, can be just about anything involving the ownership of real property.
So what would be the circumstances that would require the filing of such a lawsuit?
There are many, many circumstances which can give rise to the filing of a quiet title action, and they generally fall within two categories, whether it's disputed or whether it is undisputed, and it's just to correct a technical error in the chain of title. Mm-hmm. And I would say that the majority of quiet title actions that are filed with the court are to correct a technical error in the chain of title. And these can be all sorts of things. I recently filed a quiet title action where I had somebody had purchased property. It was actually a developer had purchased property, an investor that was planning to flip it or rent it, and we did a title search. He bought it at a tax sale. And we did a title search, and I had to file a quiet title action. There were 4 different problems in the chain of title, and this often happens with properties at tax sale. Two of them were with respect to tax sales themselves. The property had been purchased at a tax sale, and the prior owner had also purchased it at tax sale. There were issues maybe with some of the notice that was given when the sale was done and things like that. Also, there was an erroneous legal description. The legal description of the property actually described another parcel. It had accidentally it was just a clerical error when the deed was drafted, a few owners back in the chain. Mm-hmm. And the fourth problem was that there was an outstanding private mortgage. One of the prior owners had obtained some financing actually from his mother, and his mother had taken a mortgage against the property. Apparently, son had probably repaid the mortgage at some point, but it remained of record. Mom had never filed anything with the court to say, hey, this is paid. So it remained a lien of record. So we had to file a quiet title action setting forth all of those different problems in detail and giving notice to all of the prior owners that were involved. And ultimately, you get an order from the court saying, okay, the quiet title action, proper notice has been given, and they enter a judgment saying, okay, the current owner has good title.
So you and I have talked in the past about title searches and determining what are the boundaries of a property. And off in the woods, there's a tree stump painted white, and that's the border. Those sorts of things. And tree stumps change over the course of decades. And maybe you can't find what that border is. Would a quiet
Absolutely.
Title auction or action actually be a part of that whole process?
Yeah, those types of arcane legal descriptions where you've got boundaries that have shifted or that can no longer be found, or old surveys that conflict with other surveys. I mean, you have various neighboring parcels that have had surveys done over the years, and there's conflicting boundaries, and these are what can lead to some of these contested quiet title actions where there's one owner says, well, I own to the road, and the other owner says, no, I own on the other side of the road, and so it's you can file an action in court and say, Judge, we need to get to a trial here, and have our surveyors come in and give expert opinions and present evidence to get a judgment as to who owns this particular part of the property and where the boundary line is. So that's another common reason that someone might file a quiet title action.
Now, you use the word contested. Would a quiet title action be the proper use for something that it's not really contested, it's just two property owners just want to know for their information?
Well, you generally don't go through a legal proceeding like that. That can be expensive and drawn out. If it's amicable. If you just say, well, we just want to know, then let's agree to have a new survey done. Let's maybe share the cost of that survey. Figure out where a modern surveyor puts the boundary, and let's file deeds signed by both parties that agree to a boundary line. It's much cheaper to reach an agreement in that situation, if at all possible, than to proceed with a legal action to determine your property rights.
Tell me the origin of the term quiet title action. Why did they determine that would be the best way to phrase that?
Well, that's a good question, Todd. I don't know the exact etymology of it, but I would say that that probably it comes from the fact that a chain of title, when you build a chain of title, each owner passes ownership, conveys ownership of real estate to the subsequent owner, and that creates a link in the chain of title. And you want this to be a very smooth, you don't want there to be any issues there, right? You want it to be a very smooth and calm linkage of title. And I would say that the name of this probably comes from the fact that there's some consternation, some issue with the chain of with these links, with this chain of title, and you want to quiet it down. You want to smooth it out.
Mm-hmm, mm-hmm. Final determination when a quiet title action is filed, is that the judge's sole responsibility, or do these things frequently get worked out between the two sides?
Frequently gets worked out. Like I said, often they're uncontested, and you're going through the motions of making sure that the problems are laid out correctly before the court and providing notice to every party. A lot of times you've got to provide notice to their heirs, and sometimes multiple generations of heirs, depending on how far you're going back. These issues go back. If you've done all that, you get an order. Most of the time, I would say these are uncontested. And if you get people that respond when you file, then you've got to explain the situation to them, and usually they understand. But most of the time they are uncontested. They certainly can be. Certainly can be litigious, and as with most lawsuits, the vast majority of cases do end up settling before you go to a trial because of the uncertainty and expense of trial.
It's interesting. When we have these types of discussions where there is a dispute between two or more parties and the attorneys therefore get involved, sometimes somebody takes it very seriously and they hire an attorney who does every step that needs to be taken and is able to help to come to a resolution. The second party in the dispute might not take it seriously at all and just say, I'll handle this myself, or my uncle's cousin's friend went to law school for a couple of years and we'll let them handle it. When those things happen, people put themselves at an automatic disadvantage, don't they?
They do, and this is these types of disputes over real estate. Usually, people realize pretty quickly that they're in over their head. When you get a 45-page complaint served on you, detailing the chain of title for your land going back 100 years, and all of these specific legal problems with the title or the specific reasons that someone has filed this against you, you realize pretty quickly that that Google lawyer or AI lawyer isn't gonna be able to fix this problem for you. So you do have to get legal representation.
Oh, see, you just opened a whole can of worms right there, because I have been meaning to ask you about AI lawyers, Google AI or whatever the AI program is that you're using. There is a real danger that people are going to rely on that to be their legal advisor. And boy, is that a bad idea, huh?
AI is it's obviously coming along and becoming a part of all of our lives, even though we don't want it to, maybe sometimes. But AI is good for certain things, and legal representation is not one of them yet. The law is too complicated. The facts of every case are so different, and it's we could talk about this for a long time, because there have been all kinds of issues that have been popping up around AI in the legal profession. But suffice to say, do not go on ChatGPT or Meta AI or any of these other AI tools and try to argue your lawsuit yourself.
and don't ask your AI lawyer to file a quiet title action on your behalf either.
That's right.
But if you want Marshall Chriswell to get involved, what should they do?
You can call me 724-465-5826. Stop and see me in the old RMP building behind the post office at 655 Church Street here in Indiana, or go online, check us out at www.westernpalawyer.com.
There you go, Marshall. Thanks so much. Have some hot chocolate, will you?
All right, Todd. Stay warm.
It is the voice of Indiana County. It's WCCS 101.1 FM, AM 1160, and WCCSradio.com.